Martin Molina.
Martin Molina, I'm going to send you to breakout room number 2. And there is a James Jordan in breakout room number 1. Could someone go and tell him to remove himself from that room, please?
I'll go, Judge.
Thank you. We're going to go back on the record in 2019 CR 8157A. Could I have parties announced for the record, please?
Tom Nisbet for the state.
Your Honor, Mark Braswell for the defense with my client, Victor Fernandez, who is in person in court.
All right, the court had made its ruling before the break, and both parties asked that I hear new evidence. And there was a request for me to withdraw or give a new trial as it relates to sentencing, and the court agreed to do that and ordered that. So there's new information. Is that correct?
Yes, Judge. And with the court's leave, and obviously I have defense's permission to just make a small proffer, despite this being a silent plea. It is the position of the parties and our proffer to the court that Ms. Skripka would like the court to give the defendant a maximum supervision term on deferred adjudication to accommodate his aviation licensure, as well as the opportunity to pay back the restitution to Miss Amber Skripka and her family for everything that they've lost through this exchange. And so she expressed her gratitude to the court for reading her letter, for taking it so sternly, and for reacting the way the court did. And she would just like to maybe soften our position as the state just a little bit in making that request to the court.
All right, defense.
Your Honor, we have no objections to that recommendation.
All right, Mr. Fernandez.
Yes, Your Honor.
All right, if you're tested today for drugs, what are the results going to be?
Negative, Your Honor.
Have you ever used illegal substances?
When I was a teenager, Your Honor.
And what was that?
Some marijuana, and I tried, I think, some acid. Something else I tried. What was it?
All right, is there anything else you wish to say, Mr. Braswell?
Your Honor, I would just ask the court to please consider the state's comments. I mean, he's speaking for all of us. We've conferred over the lunch hour, and I also had an opportunity to speak with Ms. Skripka, and it was very productive, and we want her to be made whole.
This is what the court is going to do. Mr. Fernandez, the court was strongly and wanted and thought that this case deserved a prison sentence. You understand that?
Yes, Your Honor.
One of the main reasons why you're not going to prison is because the complainant in this case, Amber Skripka, has shown you mercy by asking the court to give you deferred adjudication. Do you understand that?
Yes, Your Honor.
So you really need to remember that. You are too old to be racing. You understand?
Yes, Your Honor.
So are you still driving?
I drive, I do a handyman job right now.
No, my question is, are you still driving?
Yes, I'm driving.
State defense, how are we addressing this issue? Is there any concerns with his driving?
I mean, insofar as he has to earn a living and continue to comply with Texas Transportation Code and, right-of-way safety driving provisions, it's almost a necessity. And I guess the state would still consider it. Obviously, you don't even have to make a probation condition that he should comply with safe driving. It's kind of in and of itself. It's contained as part of his supervision. So I guess with the court's admonitions to the defendant, it's carried with his probation that he had better be a good driver out on the road, or there are very, very serious consequences with an orange jumpsuit at the end of it.
Mr. Fernandez, do you understand that?
Yes, Your Honor, I do.
All right, anything else from either party?
None from the state.
All right, this is what the court is going to do. 10 years deferred adjudication. There is to be restitution to Amber Skripka in two amounts, $10,185.88 and $238,538.15. With regards to the restitution, if something happens through insurance or with attorneys on the civil side, the court can always revisit that because no one's going to get paid double. Taking consideration 2019 CR 8155B, 2019 CR 8156B, 2019 CR 8158B, 2019 CR 8159B. There's to be regular Zoom reporting or in-person reporting if you don't have access to Zoom. There's to be random UAs, or you can do a patch. There's to be proof of employment within 15 days. And Mr. Fernandez, there's to be no drinking of alcohol while you're on probation, even at your own home. Do you understand?
Yes, Your Honor.
And I hope you realize that a number of people could be dead right now because of your actions. Do you understand?
Yes, Your Honor, I do.
Rebecca, is there anything else that Mr. Fernandez needs to be successful?
No, ma'am.
Mr. Fernandez, I'm going to ask you what I asked everyone that is placed on probation in this court. Is there anything else that you need in order to be successful on this probation?
No, Your Honor, I will be successful.
All right, I'm going to show you a document entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, I did.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, with that, we will close the record. State, is there any victim impact?
Yes, Judge, there is.
And who would that be?
Amber is going to make a statement, and then I think we were going to discuss whether her grandfather would make a short statement as well.
All right, Mr. Fernandez. In the 187 District Court, I require that everyone treat everyone with respect. It doesn't matter who you are. You understand?
Yes.
So my understanding is Ms. Skripka has a victim impact statement. Hear what she's saying, internalize it. Ms. Skripka? I'm sorry, we can't hear you, Ms. Skripka.
Yes.
Can
Amber,
you hear me now?
Yes.
Yes, we can hear you now.
Okay, I apologize. I'm going to try to get through this as quickly as I can.
No rush.
Yeah.
Okay, thank y'all so much. Dear Mr. Fernandez, my family and I have been through inexplicable pain due to your actions. I honestly don't even know where to begin. I imagine the best way to begin is from the very beginning. It was April 25th, 2018. I was due to be at work for my usual shift at the University of Texas at San Antonio. Department of Public Safety for my usual shift at 8 a.m. I was almost to work when the incident occurred. It happened out of nowhere. I never even saw it coming. One moment I was in my car listening to my radio. I apologize. And in the next instance, I remember just closing my eyes and hearing a very loud sound. And I was squeezing my eyes so tight. It felt like I was spinning around in a Ferris wheel that was going super fast. I just remember hearing so much scream. As soon as my vehicle stopped spinning, I opened my eyes and I just remember everyone about me screaming. I remember knowing that I must have been involved in some sort of accident, but I had no idea how bad it was or what had actually happened. I heard everyone screaming at the intersection, and while I was still trying to figure out what had actually happened. I remember a male walking up to my window in the vehicle to ask if I was okay. As soon as he looked into my vehicle, he screamed out to the crowd that we need EMS. He looked down at my arm, and when he looked down at my arm when he was saying that, so I looked down, and that's the first time I noticed that something was wrong. I saw blood everywhere, and I remember seeing some yellow, what looked like to be fat coming out of my wrist area. I immediately went into a panic, and I started to have an immense fear for some reason that someone was gonna try to hit me again from behind. So I tried to get out of the car. I remember the male that came to help me was telling me to stay still as possible and to not move. But I couldn't. I had to get out of the car. So I unbuckled. I opened the door and I got out of the vehicle. I remember as soon as I got out, I turned around and I saw the ambulance, thank God, was already pulling up to the scene. I remember holding my ring finger and my pinky finger in my hand and trying to squeeze it to see if I could feel it. And for a brief second, I was relieved to know that I still had feeling in my hand. At that point, I still hadn't had any pain. I was still in shock. The EMS responders immediately got me into the back of the ambulance and started taking my vitals and doing what they needed to do to keep me as safe as possible. I remember there was a super sweet lady that was standing with the ambulance doors were open, and she was standing looking at me, asking me if I needed anything for my vehicle. I said no at first, but she was like, do you want your phone? And I was like, oh my God, yes, I have to tell my mother what has happened. So she went to the car to try to get my phone for me. And I know as soon as the first responders got my phone and started calling my mom, I heard my mom's voice. And I don't know why, but right then it all started hitting me. The pain it was immense pain right away. And I remember just screaming to the poor first responders, like, I need pain medicine. I need pain medicine. And the next thing I remember, like, I must have passed out, because the next thing I remember, I was at the hospital ready, and everybody was standing around me taking pictures of me. And my mom was already on the phone by my bedside. And to the right of me, there was a lot of detectives from my work. They were already there because I was working for the police department at the time, so they had heard what had happened. And they actually, after talking to them afterwards, one of the dispatchers, they had got the call from SAPD that it was a fatality accident. And when they ran my license plate, they knew it was me, and everybody thought I had died. So I remember talking to them afterwards, and they were so happy that when they got to the hospital, they knew that I was actually alive, and they were in super shock that I was still alive. So after I woke up at the hospital, I remember the nurse cutting off my pants and taking a lot of pictures. And then I must have gotten wheeled into surgery, because the next thing I remember, I was in the hospital room in the ICU, and all my family was there, and they started telling me exactly what had happened and where I was, and a detective was there to explain to me what they thought had happened. As a result of this incident, I had 15 surgeries on my arm, and I still need at least one more, and I have a follow-up next month on the 20th to see when I can get that done. The first major surgery was the first day I was there at the hospital. They had to put my veins and arteries back together to try and keep the blood flowing to my hand so I wouldn't lose it. And they took out all the skin that was dying or dead. They also set my bone, or what was left of it, they set it in one place with metal screws and plates. I didn't even know until about a year after my incident, when I was at the hospital for a follow-up, one of the doctors had told me that they got the call to come in that day and amputate my arm. I'm so grateful. Even though I was in a very unlucky situation, I was so blessed that Dr. Colmack and Dr. Carrier were there at the hospital that day because they saw how young I was and they didn't think it was going to work, but they tried to do an experimental procedure and it ended up working. And that's why I have my arm today, because they took the extra time and effort to try this procedure on me.
Miss Script, just
Yes.
slow down a little bit.
Okay.
But I want you to know that the court understands your pain, and the court reviewed your victim impact letter. And I know that that letter has been shared by defense to Mr. Fernandez.
Okay. I didn't know they had read the whole thing already.
No, they read the whole thing. I make sure that
Okay.
the state, the defense, and I also make sure that the defense have their client read the entire the victim impact and the entire PSI report with their client. So Mr. Fernandez has, I assure you, been given that by his attorney to read.
Yes.
But
Okay.
I appreciate you so much for coming in.
Yeah, I appreciate it. If I could I just wanted to add a couple things that weren't in
Sure.
my initial letter that y'all read.
Sure.
I just wanted y'all to see that I forgot to put it in my letter, but everyone at my work was so supportive of me. And it's because of them and my family that I'm actually here with y'all today, because I feel like mentally it was so taxing on me. And I remember when I first got back to work after being out for almost a month and a half, everybody at work had, I don't know if you can see it, but they made up these little Amber Strong bracelets for me. And everybody at work was wearing them, and they were trying to raise some money to help me pay for my bills. It was just so sweet. And also, I know y'all, I did send pictures, but this is updated after all the surgeries. My next surgery is going to be to try to fix this, like the unevenness of it, and to try to even out some of the stiffness in my wrist. But I mean, this is going to forever be my arm. So I just wanted y'all to see it as it is right now, 3 years later. And I do have a lot more victims impact statement, but if y'all have already read it, I don't want to tie up the court's time anymore.
Well, Ms. Scripta, let me just tell you, you never tie up the court's time. And I just want to let you know that everyone here is very sympathetic and empathetic to what you've been through. And I appreciate your coming in to tell us your story and what happened, okay?
I really appreciate it. Thank you.
All right, thank you so much.
Thank
Is there
you.
going to be another statement, State?
Amber, does your grandfather want to make a statement?
I believe he's on and he would like to speak. And I do have a lot of family that would love to speak to, Judge, but I know that if you don't have time, I understand that that's not easy to allow.
Okay. Who is the grandfather? What is his name?
It's Dr. Stephen Schenker.
All right, I think I see him here. All right, Mr. Shankner, could you please unmute yourself for me? Just 1 second, I can't hear you. Do you see where it's popping up asking you to unmute yourself?
No.
All right.
Yes, this is Dr. Stephen Schenker. Judge, I'm very appreciative of your efforts in this case and the help we have received. Amber is my granddaughter by marriage. I'm a professor of medicine and have been practicing medicine since 65 years ago. I was chief of GI at the medical school here, and I was very, very close to Amber when these procedures were being done. 15 difficult surgical procedures. There is no compass in medicine for how to proceed. And I'm proud of my colleagues for being able to restore her function the way they have. She will never be quite the same, but she has done very well considering the injury that happened to her. And I'm grateful to you, ma'am, for taking care of this problem for us. I think that she has already been awarded a Merit of Courage by her colleagues at the Department of Police. And I remember seeing the head of police department say crying as he gave her the award. The whole group stood up and cheered to give her a recognition for her courage. So we felt as a family that we owe you a great deal of thanks for the proceedings here, and we hope that Amber will do well.
All right, thank you so much, and thank you so much for coming. It's greatly appreciated that you give us insight into Amber, and it's a testament to the people at her job that they were there for her as well. So I appreciate you all coming. Mr. Fernandez will, as I said, be supervised by the court. So we're going to make sure that he is doing everything that he's supposed to be doing. He's been given a chance, Ms. Skripka, based upon your mercy upon him, okay? So with that, I'm going to
Thank
send.
you, Your Honor.
Oh, you're
I
welcome.
appreciate it so much.
Oh, you're welcome, and take care of yourself, okay?
Thank
All right.
you. You
You're
also.
welcome. So courtroom, I'm going to send you to a breakout room so that probation can give him what he needs to do to be successful on probation. So courtroom, if you'll go to breakout room number 1, and probation, if you'll go to breakout room number 1 to go over conditions with him.
Yes, ma'am. Thank you.
All right, thank you. And Mr. Braswell, you can
Yes.
go to breakout room number 1, and once the conditions are gone, you're excused. You won't have to come back to the main room.
Thank you, Judge.
You're welcome. All right, and I believe Dan Rodriguez, you're here with Mr. Salazar.
I have Salazar and Mr. Riley Hood.
All right, what is happening with Mr.
I
Salazar?
abbreviated what I
We
said.
had I filled out plea paperwork, but Mr. Salazar still hasn't signed any plea paperwork. And I also have filed a motion to reinstate his bonds.
All right, Mr. Salazar, I'm going to send you to breakout room number 2 with your attorney so that the paperwork can be completed. Ed Bartholomew. Ed Bartholomew.
Here, Judge. Sorry.
Hi, I'm going to send you to a breakout room with Norma Ferguson so she can let you know what's going on.
She called me,
Norma?
Your Honor. I do know. I have photographs. He is in the hospital and he did have a stroke. So his wife would like to recall the warrant.
All right, so this is what I'm going to do. Ed, I'm going to send you to breakout room number 3. Is your client with criminal trial division or family violence?
Criminal trial, I believe, Judge.
All right, could somebody from criminal trial division meet Ed
Ruben
Bartholomew?
Hernandez.
Pardon?
Ruben Hernandez.
All right, it's Ruben Hernandez. If someone from criminal trial division could go to breakout room number 3 with Ed. All right, and then Christopher Donaldson, who's the attorney for him? What is happening with Mr. Donaldson?
Judge, that's me, Your Honor. If I could, I don't know if Tom's available to go to a breakout room or not.
Did you paperwork?
Okay, I guess he's not available. Just need to tell him something.
All right, I sent you to breakout room number 4.
All right.
And then Brent Coffey, are your witnesses here?
Good afternoon, Judge. First, no, my client will not be attending court this afternoon for this contested MTR.
Why will he not be attending? Did he not like the invitation? I mean, did he want tea and crumpets?
He informed me this morning that he's come down with COVID. I have no documentation or anything for that, but he will not be appearing in court this afternoon.
All right, because I always wonder, what type of service, Brenda, I'm from the South. I mean, we can send out some engraved invitations. All right.
Judge, I've prepared for this case. I know I've been on it for several months, this MTR. I'm prepared to cross-examine any witnesses the state has, but obviously my client is not present in court.
No, I appreciate that. We're going to go on the record very briefly. Courtroom, Deputy Mejia, are you available briefly?
Yes, ma'am.
Victor, please.
All right. The court is calling 2017 CR 4615 and 2021 CR 0832, State of Texas versus Juan Carlos Castañeda. Could I have parties announced for the record, please, for the state,
Jordan Brown for the state.
for the defense?
Brent Coffee.
All right, this case was originally, let me go through the history. This case was set on January 6th for a contested motion to revoke. Then it was reset for January 27th. At that time, there was an agreed continuance, and it's recalled for February 24th, 2021, I'm sorry. Then it was recalled for a contested hearing on March 17th. And now we're here on March 24th for a contested hearing. Deputy Mejia, has there been a Juan Castañeda in the courtroom at 1:30 this afternoon?
No, he has not.
And for the record, it is now 2:30 p.m. and there's not a Juan Castañeda on the Zoom screen. Defense, have you had any contact with your client?
Yes, I have.
Yes, and why is your client not present?
I've had contact with him as late as this morning, or as most recent as this morning. He will not be appearing in court today. He informed me that he has come down with COVID. I've received no documentation regarding that, but he will not be appearing today.
All right, state.
Judge, state would request that the court issue a warrant for the defendant's arrest and forfeit his bond. Obviously, no objection if the court wants to reconsider that with proof of COVID. But at this time, we're requesting the warrant and the bond forfeiture.
All right, I'll grant the state's motion and I'll remand him without bond in each case. Counsel, if you're able to receive documentation from your client of any type of medical issues that precluded him from being available for this hearing today, I will, of course, reconsider.
Thank you, Judge.
All right, thank you. With that, we'll close the hearing on that case.
Your Honor,
Yes.
on Mr. Hernandez, they're agreeing to reinstate his bond 217 CR 2957.
All right, Norma, if you can have them pull the B page for that and give me the file on Ed Bartolome's client.
Yes, ma'am.
Good morning.
All right.
Good afternoon, Norma.
Everyone,
Excuse
just give me 1 moment, please. But you are excused, Mr. Bartolome.
Judge, can you assign Lenny to a breakout room? Just signed in. I think that's one of my witnesses.
Lenny, if you'll go to breakout room number 3, please. All right, Ross Rodriguez on Mr. Donaldson.
Judge, could we go to a breakout room real quick? I've already spoken with Tom. I just need to let the court know something.
Oh, okay. Let me see. If you'll go back to breakout room number 4, I'll meet you there with the state.
Thank you, Judge.
Sure. Mr. DeWiggins?
Yes, Your Honor.
Yes, who are you here for?
George Gutierrez. He said he was in the waiting room.
I'm waiting for someone to be on the screen. Mr. Gutierrez, I don't see him.
I don't know. Is that him on the Alcatel axle?
I'm not sure. Just give me 1 moment.
Okay.
Are you Mr. Gutierrez? All right, just give me a moment, Mr. DeWiggins.
Yes, ma'am.
Let me put Tom in 4. I'll be right back.
Norma, can you hear me?
I think she stepped away.
Okay.
Mr. Donaldson?
Yes, ma'am.
All right, so here's my question. I've had a chance to talk with the state, and I've talked with your defense attorney in the breakout room.
Yes, ma'am.
So are you accepting this offer on this possession less than a gram case or not?
Well, that's what I was talked to the investigating
Well,
officer.
here's the thing. I gave you time to talk to whomever you needed to talk to. That's why I was recalled today.
Right. And that's what I did. I had spoken to the investigating officer and he
No,
said,
no. You said you wanted to speak to your mom.
yes, I did. I did speak
And
with my mom.
so that's where we are. So either you want to accept the offer or you don't want to accept the offer.
Okay, but I don't have a chance to work the cases off.
Excuse me, I don't think you want to be saying that on YouTube. We are live on YouTube,
Oh, okay.
which means
I'm-
that the entire public will be hearing this. So
Okay.
what I have before me, what you're charged with in Bexar County, unless the state has a different view, you're charged with possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine.
Yes,
My
ma'am.
understanding is that an offer has been extended. That offer was extended yesterday.
Right.
You said you wanted to talk to your stepfather who's going through chemo and
Yes.
your mom.
Yes.
And I asked you how old you were and you told me.
Yes.
And I told you, as I've told everybody, you're old enough that you can make this decision on your own, but I still gave you a chance to speak with them. So you have spoken with them. So either you're accepting the state's offer or you're not.
I guess
So
I am.
if you're not accepting the offer, then it'll be going to jury trial and the court will not accept any plea bargain agreements.
Okay.
Do you need to speak with your attorney?
Yes, ma'am.
That's not you, Mr. Alcantel. Mr. Jonathan, do you
Sorry,
need to
I'm
speak
sorry.
with your attorney?
Yes.
All right, I will send you to breakout room number 4. Mr. Rodriguez, can you go back to number 4?
Me, Your Honor?
Ross Rodriguez.
Okay.
I'm sorry, Dan.
I'm trying to do the plea paperwork for Mr. Salazar, but his computer or whatever, he's not allowed to share the screen.
All right, he should be allowed to share now. If not, just let Norma know and then the deputy will be made co-host and he can share it.
Okay.
All right. Trey Duncan and John Kuntz.
Hello, Judge.
Hi, have you had a chance to speak with the state with regards to the alleged violations?
Judge, first thing this morning, you put me in a breakout room that I was in for an hour and no one came in, and then I had to jump on another one, so I apologize. But Tom Nesbitt and I texted early this morning, well, during Docket earlier, and I don't believe he can agree to anything.
Okay.
I see him shaking his head.
Okay. So we will take up Mr. Duncan. There, that makes it easier. All right, the court is calling 2020 CR 6711, State of Texas versus Trey Duncan. Can I have parties announced for the record for the state? You're muted, Tom.
Sorry, Judge. Tom Nisbet.
For the defense.
Don Kuntz for Mr. Duncan.
And are you Mr. Duncan?
Yes, ma'am.
We're proceeding by video because of the pandemic. Any objections from the state? Any objections from the defense?
No, Judge.
I'll note for the record that Mr. Duncan is in the courtroom. This is one of the days the court is allowed to have in-person hearings. We're here on a second violation report. The defendant previously had a first violation report, and it was in relationship to violation of GPS inclusion zone. The court had the defendant to appear on that day, that a defendant appear by Zoom, and the court admonished the defendant not to violate the GPS inclusion zone. And the court specifically instructed the defendant that if there were issues where he needed to travel, that he was to call pretrial services officers beforehand and call his attorney. So now we're here for a second violation report. Have both the state and the defense had a chance to review the second violation report?
State, yes.
Yes, Judge, we have.
All right.
I can try to clear this up in 20 seconds if that's okay.
Okay.
So
go ahead.
And I have Trey's mother's here to testify, because if you'll look at the map, Judge, where he went out of his neighborhood was literally right across the freeway, basically from their neighborhood. His mother's car had broken down and he went there, and you can see he was only gone from the neighborhood for just a matter of a few minutes. And his mother's here to testify about her car breaking down that evening. He helped push her car into a parking lot.
So
And
here's my question again. Why did he call somebody?
He did call Officer Tatlow.
All right, let's see if where's Officer Tatlow? That's
right
going
here,
to be the question.
Can you hear me, ma'am?
Yes. All right, Officer Tatlow, can you raise your right hand for me, please? Do you solemnly swear the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
You can lower your hand. Would you state your name for the record?
Officer Tatlow.
And what's your first name?
First name, Jonathan.
And how do you spell your last name?
Tatlow.
All right, if the defense or the state wish to question the witness.
Go ahead, John.
Okay, thank you. Officer Tatlow, I'm sorry to bother you. I know you've been on the Zoom all day. I'm sorry about that. Did Trey leave you a message the night of the violation?
No, sir, none at all.
Okay, did he?
I even contacted the on-call officer asking if the defendant may answer the phone when they tried calling him. They said that he did not answer as well. They left a message to him and his mother's phone, but there was no answer.
Okay, and so this was all the same night that of violation?
Yes, sir, the same night and the next morning.
Okay. Are you aware of the status of his phone currently?
No, sir, he hasn't updated me of any phone issues.
Okay. Okay. Judge, I don't have any further questions of this witness.
State, any questions?
No, Judge.
All right, thank you, Mr. Tatlow. Is there anyone else you wish to call?
I would call, Trey, is your mother there still?
Yes, sir.
Can I call his mother, please?
Yes.
Thank you. Her name is Pinky Johnson.
All right, if she can come up, please. All right, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand and I'm going to need you to speak up. Could you state your full name, please?
Pinky Elaine Johnson.
All right, defense.
Good afternoon, Ms. Johnson. I'm sorry to keep you waiting all day. Let's talk about a couple of Saturdays ago, I believe it was, when your car broke down.
Yes.
Where did it break down?
On I-10 near WW White.
Is that near your house?
Yes, it's like right in back of my house.
And so the neighborhood that you live in is kind of right along I-10, isn't it?
Yes, right in back of it.
So what happened to your car?
I ran out of gas and I needed somebody to come and help me push, and Trey's dad was on the other side of town, so I just called Trey to come help me push it out the way real quick.
Did he help you push it into a parking lot?
Yes.
What was the business, the parking lot?
Exxon.
Okay. Was there also a motel nearby?
Yes.
Did you have to push, or did he walk through or go through the parking lot of the motel that's next to the gas station?
Yes.
Okay. Now, how long do you think Trey had actually left his house?
It had to been no more than 10 minutes.
Okay. And when you guys were finished there, did Trey go back home?
Yes, he did.
And the judge swore you in. You're telling the truth, aren't you?
Yes, I am.
And to your knowledge, did Trey try to call pretrial?
Yes, he did. He called and left him a message.
Okay. Was it that same night?
Yes.
And how do you know that he did? Were you there when he made the phone call?
I was.
And what did he say?
He said, he said, Jonathan, this is Trey Duncan. I was just calling to let you know that I'm gonna help. I have to help my mom move her car off the highway.
Okay. And then did he ever get a call back?
No, sir, he did not.
Did you ever get a call from pretrial or your husband?
No, sir.
Okay. And you and I talk pretty regularly, and you answer your phone generally when I call, right?
Yes, I do.
And do you answer the phone normally when someone calls you?
Yes, I do.
So you're not a criminal, are you?
No, I'm not.
Okay. And neither is your husband, right? So is it possible that pretrial was reach out to you or to Trey and you guys just didn't answer the phone?
But no, because he told Trey whenever he need to leave to just call and leave him a message, but he never calls back.
Okay. When you say he never calls back, has Trey called before?
Yes, that's how Trey that's how Trey communicates with him. He told him in the beginning, whenever you need to leave, just call and leave me a message.
Was Trey doing anything other than helping you that night?
No, sir.
Was he out running the streets or anything like that?
So he was not.
Was he acting in a bad way or anything that night?
No, sir.
The only reason he left the house, and which again was just right across the freeway from where your car had stopped, right? The only reason he left was to come help you push your car, right?
Yes.
Okay, I have nothing further. Thank you. Pinky, the prosecutor may, or the judge may ask you some questions.
Hey, any questions?
Judge.
All right. All right, you may have a seat.
Thank you.
Trey, you stay there for a second.
Defense, any other
I guess
witnesses?
I will ask my client to testify, Judge.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Do.
I'm gonna need you to speak up.
Yeah, I do. Yes, ma'am.
You can lower your hand. Defense?
Trey, let's talk about the violation. You just heard your mom testify. When you left the house, did you try to reach your pretrial officer?
Not before I left, but after, when I got.
Okay. So how did it go down? Did your mom call you or text you or what happened?
Yes, sir. She had called me and told me that she had ran out. Car had stalled on 10.
And did that concern you?
Yes, sir.
So what did you do?
Well, I had put my shoes and stuff on, and I had ran across the highway, and I seen her.
So you actually ran over there?
Yes, sir. I pushed.
Okay, you didn't drive or anything like that?
No, sir. I had walked.
And so when you got there, what did you see?
I seen her. She was outside her truck, and she was right there waiting. So I had pushed her. I had pushed her into the gas station, and then she told me to run back around to the house because she was going to get something to eat. So she told me to run back to the house while she pumped the gas and went to go get something to eat.
And then is that when you called Officer Tatlow?
Yeah.
And how long do you think you were gone from your house?
I say about 15 minutes, about 15 to 20 minutes. It could have been longer. I'm not sure.
Okay, but it wasn't a long time.
No, sir.
All right. Is that the only place you went?
Yes, sir.
You weren't up to no good, were you?
No, sir.
Okay. Did you receive any phone calls from anyone from pretrial the next day or anything like that?
No, sr.
All right. Does your phone block those numbers or anything like that?
No, sir. My mom have all the text messages and calls from pretrial services because I told her not to delete nothing. I asked if she don't delete nothing so I can have it to see.
And in fact, the phone that they contact you on is probably your mom's phone, isn't it?
Yes, sir.
Okay. Do you have your own cell phone?
Yes, sir. I recently got one.
Okay. So, but neither you nor your mom got any phone calls from pretrial that you saw?
No, sir.
Okay. All right, Judge, I'll pass the witness.
All right, stay.
No questions.
All right, any other witnesses?
No, Judge.
All right, I'll hear argument.
Judge, you heard from the GPS officer, Mr. Tatlow. There was no phone calls. And now you're going to hear from the defendant. We'd argue it's self-serving. We'd argue that we have made extensive provisions to both agree to reduce his bond in the past as well as Give More Forgiving GPS. And literally 5 days after you admonished him, do not do this, he went and did it. So it would be the court's determination on credibility and the feasibility of mouthwash type stories. And we would leave it up to the court's discretion, but we are not in agreement, obviously. And this the state's position that I don't really know if we're buying it. I rest.
Defense?
Judge, I know it's unfortunate that we're right back in front of you on the same type of issue, but when you look at the map that pretrial has provided where my client went, it's exactly where he and his mother have told you he went. There is no, he wasn't all over, driving all over or walking all over anywhere else. And when you look at how much time he was gone from the house, it was literally not that long. So his mother is a wonderful woman. I deal with her all the time. I don't believe she has any sort of criminal history. She is not going to come in here and tell you something that's not true. They have been consistent from the day we got that violation report and I talked to them. They immediately knew, no, that was when Trey was, helping push the car, sort of thing. So I know it's unfortunate that he violated that term, but I think it was obviously just a very temporary thing. His mother was broken down on the side of the freeway, basically. So he did what I think most people would have done. And then he apparently attempted to contact pretrial. And I think this goes back to what we discussed at the last hearing, Judge, which I think there's some breakdown in the communication. I don't know where it's coming from, but ideally, I think what I would like, and I would request again, like I requested at the last hearing, is an email so that he can email the pretrial services department, whether it's Officer Tatlow or someone else on the weekends or whoever, and he can CC me on the email saying, look, I'm emailing them. I had to go help my mom, sort of thing. Obviously, we don't want him to leave the jurisdiction again or the GPS location again. But if, God forbid, he had to, I would at least like there to be a paper trail. And so based upon that, Judge, I don't think Trey was doing anything to flaunt or to be rude to the court or anything like that. We would just ask that you continue him. This was, again, something that just him helping his mom for a very, very brief period of time. And then he went right back home.
Okay, I don't understand what people don't understand when they're on GPS. Honestly, I don't even understand why your mom would call you knowing you're on GPS. I don't understand when you were here last time and I told you if there was an emergency, you needed to call your officer first before you even decided to leave. I don't understand why people are leaving the home and they don't have enough gas. And the fact that you're saying that you pushed her to a gas station shows there was money for gas. And your attorney is telling me this happened on a Saturday. I don't understand why you were out, because what I put in place as a sanction for you was that you are not to leave home on Saturday and Sunday. You had a curfew on Monday through Friday till 5 p.m. So this is what the court is going to do. You can stay on bond, but I'm amending your conditions. It's full GPS until further notice. If your attorney wants to come back in a couple of months and see if I will change that, but for now, it's full GPS. So I hope you know you are not allowed to leave your house. Do you understand?
Yes, ma'am. At all now?
At all.
Yes, ma'am, I understand.
And depending on how big your backyard is, you may not be able to walk to the fence line or to the property line. You understand?
Yes, ma'am.
Yes, Mr. Tatlow.
Being full house arrest, how we have it set is he can't exit his front door. He can't even exit his back door. So even if he steps out from the back door or the front door, he's in violation.
There you go. You're staying inside your house. You understand?
Yes, ma'am. I do that anyway.
No, you don't, because you just went and violated your probation to go help your mom.
Yeah, I understand that, but besides
So here's the thing. So I want the record to be clear.
yes, ma'am.
If your family is having a barbecue in the backyard, you can't go in the backyard.
I understand.
If somebody rings the doorbell and UPS or Prime or whoever it is leaves a package on your front porch, you can't go out and pick it up. If your mom comes to the house and she's outside in the driveway saying, help me with my groceries, you can't go help her with the groceries. You understand?
Yes, ma'am.
And we are here where we are now because you can't follow rules. This is the second time you violated your GPS. All right, with that, we'll close the hearing.
Thank you, Judge. May we be excused?
Yes.
Thank you.
May I be
Mr.
excused too?
Coates?
Yes, ma'am.
Before you leave, did you need to speak with Mr. Tadlow and get your email address?
That would be wonderful.
All right, Mr. Tadlow, I'm gonna send you to breakout room number 1,
Yes, ma'am.
and Mr. Coates will be in 1.
Thank you.
Ross, send me your email address.
And Brenda, you should have received that email. It came from,
Okay, Judge.
Nora. Thank you. Ross Rodriguez, what is happening with your client? You're muted. And Mr. Duncan, you can take a seat.
Judge, it's going to be a plea. I thought I sent. Oh, I need to send Tom my email.
Yes, and if you could send to Norma your client's email address as well.
Yeah.
Mr. Wiggins, what is happening with your client?
I still need to confer, Your Honor. I was in a breakout room this morning and nobody ever came, so I'm back this afternoon.
All right, what's your client's name?
George Gutierrez.
I'm right here, Your Honor.
Oh, thank you. Just give me one moment, Mr. Gutierrez. Is this family violence or?
It's a less than a gram from 2016. It's an MTR.
All right, so if you go to breakout room number 2, and if someone from criminal trial division could go to number 2 on George Gutierrez, please. Oh, Mr. Gutierrez, just wait there, okay?
Okay, ma'am. Yes, Your Honor.
And on Salazar, I believe all the paperwork is done. So Mrs. Salazar, if you'll go to breakout room number 3. Dan Rodriguez, if you'll go to 3. And if the clerk can go to 3 and swear him in, please.
Thank you, Judge.
Ross, did we do this paperwork yesterday or no? Is he in a breakout room?
He's in a breakout room. And let me see.
Here he comes.
Okay. Okay. Yes. All right, who are the prosecutors on Sebastian Salazar?
Marcus.
Okay. Dan Rodriguez, you're there?
Yes, Your Honor.
All right, Mr. Salazar, could you unmute for me, please? All right, the court is calling 2021 CR 0256, State of Texas versus Sebastian Salazar. Could I have parties announced for the record, please, for the state,
Marcus Sanders.
for the defense?
Dan Rodriguez.
All right, and are you Mr. Salazar?
Yes, Your Honor.
All right, we're proceeding by video because of the pandemic. Any objection from the state?
No objection.
Defense?
No.
Mr. Salazar, I'm showing you a document entitled Defendant's Consent to Appear by Video. Did you review that document with your attorney? Did you understand it and did you electronically sign it?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Counsel, I'm showing you what's entitled Discovery Acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor.
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Salazar, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney and did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes.
State, are you proceeding on the indictment as presented?
No, Judge, we're waiving the enhancement paragraph.
Any objections to the waiver of enhancement?
No, Your Honor.
Mr. Salazar, I'm going to show you a document entitled Court's Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it and did you electronically sign it in all the appropriate places?
Yes, Your Honor.
What you're charged with is possession of a controlled substance, penalty group 1, 4 grams to 200 grams. That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
Did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor.
You believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
You believe it's currently competent but was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Salazar, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, 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 Your
Has
Honor.
anyone promised you anything other than the plea bargaining to get you to enter this plea?
No, no, Your
Are
Honor.
you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Next, I'm showing you the plea bargain page. Did you review that page with your attorney and did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, punishment is to be assessed at 5 years in the prison. There's a $1,000 fine. There are no applications. The state will take in consideration 2020 CR 2990 and County Court Cause number 646257. Did you understand that to be the plea bargain agreement?
Yes, Your Honor.
Defense, is that the plea bargain agreement?
Yes, Your Honor.
State, is that the plea bargain agreement?
Yes, Judge.
Next, I'm showing you the paragraph entitled Waiver of Appeal. Did you review that paragraph with your attorney and did you understand it? And did you electronically sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that may be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Then Mr. Salazar, to the offenses charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the defendant's plea?
Yes, State offers States Exhibit 1 and its attachments.
Any objections?
No.
Mr. Salazar, I'm going to show you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it and did you electronically sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call them the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements, police reports, lab reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence states exhibits 1 and attachments, and the court will review the same.
Yes, ma'am.
All right, after reviewing states exhibits 1 and attachments, the court will find there sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Your Honor, we're asking for a turn-in date of 30 days and for a reinstatement of the defendant's bonds. I filed a motion to reinstate bonds, served it upon Marcus and also Norma.
All right, to the clerks in the back, I need to see cause number 2020 CR 2990.
And also 21 CR 0256 has a motion.
Oh, I thank you. Just 1 second. We'll see if I can get your motions because I don't have them.
Judge, those motions are not there?
No. And I also need both files, Norma. I only have one.
Okay, Judge.
Thank you. Mr. Salazar, I'm going to mute you for a moment because we have a lot of noise coming from your end. Thank you. And can I have the court's file on the 2990? 2021, 2990.
Okay, I got it.
All right, thank you. All right, State, have you had a chance to review the defendant's motions?
Yes, Judge.
All right, do you have any objection?
No.
All right, Mr. Rodriguez, then the question is, the court remanded your client without bond. And if this court did it, it's because he didn't show up for court.
Correct. He didn't
So-
show up for the last Zoom hearing, and part of that is the issue that I had not being able to communicate with my client and send him the link in time for him to get it.
But here's the problem with that.
I think we changed phone numbers. He changed phone numbers.
But he then would either have to appear by Zoom or in person. Because the way this case isn't just set out of the blue.
Mhm.
The only time there's a different date for a hearing is if someone is present for Zoom and the defense attorney asks for a specific setting, then the court will ask the court coordinator, when can we bring this back? So the March 11th date, he would have received notice of it to appear either in person or by Zoom. So you're not giving him a link
Mhm.
because you don't have his number. He still would have received the card saying that he was to be here on March 11th and he didn't show.
Well, if you wanted to ask Mr. Salazar what he didn't show, maybe he can explain it better than I can.
And let me just tell you this before we do that. 2020 CR 2990. In that case, that was set on May 28, 2020. Both sides asked for a regular reset. Mr. Salazar was here for that. I gave him a regular reset. Brenda, can we go on the record, please? Did Brenda have to log out? Just 1 second. I think Brenda got kicked out. All right. Wait for the court reporter to come back in.
Judge, I'm back with James from the breakout room. I'm going to be withdrawing the MTR on his client. And
I'm sorry, what?
I'll be withdrawing the MTR on his client, and the intent is to terminate the probation unsatisfactorily.
Okay, if you'll just file that, then I'll sign it.
Yes, I will.
And everyone, just give me a moment. Brenna, I think she lost the signal.
Are my client and I excused, Judge?
Yes.
All right. Ms.
Thank you for your
Gutierrez, you can
patience.
go.
Have a good one.
Thank you, Judge. Thank you, Alexandra.
Okay, Brenda has made it back in. Everyone, just give me 1 moment.
Sorry, Judge.
Oh, no problem. I'm glad that you have me hooked up with the live feed so I can see if you're typing, and I noticed there was
Did you see it?
I was like, there's nothing.
Did you see
coming.
what I put?
Yes, I did. I was like, oh. So everyone, just 1 second. All right, so we are going to go back on the record. So in cause number, Mr. Rodriguez and Mr. Salazar, in cause number 2020 CR 2990, that's an aggravated robbery. In that case was set for May 28, 2020. Both sides requested a regular reset, so I gave a regular reset. And that comeback date was on October 8, 2020. And the defendant was given a plea deadline date on that date. Then that case was recalled for October 19th because the defendant didn't show for that date. And I was asked to recall the warrant. So I recalled the warrant on October 19th, 2020. Then it was reset for March 11th. And then we have another no-show. So Mr. Salazar, there have been 2 times where you haven't showed for court. And that's an issue because part of the conditions for bond and me setting a bond is I think that you're gonna appear. So Mr. Rodriguez, I don't know if you or your client wanted to address the 2 times that the defendant hasn't appeared.
Your Honor, that would be for Mr. Salazar to answer. I can't answer that for him.
All right, Mr. Salazar.
If he wants to, he doesn't have to, but it's Mr. Salazar, if you want to tell the judge, you can.
All right, Mr. Salazar, can you raise your right hand for me, please? I know you've previously been sworn in for the plea, but not under this case. So do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand. Defense, did you want to ask him questions or you just want him to address the court's last question?
He can just address the court's last question about why he didn't show.
All right, Mr. Salazar, there are 2 times that you have not appeared for this court. And the last time I did recall the warrant.
Yes, Your Honor. I know there's no excuse for anything. It's my responsibility. And it's just the simple fact that the reason that you issued the warrant was because I was on the wrong address supposedly, and that's where I live. And I don't know, I guess it wasn't notified, or that's from what my understanding was, the times that I got arrested, or because there was 2 times that I got arrested.
But Mr. Salazar,
Yes,
after
ma'am.
the March 11th, I'm sorry, after the October 19th date, when I recalled the warrant, you would have known about your new court dates and you just failed to appear.
What was it? I think October.
October 19th, there was a warrant issued for you. And I recalled that warrant. And that warrant was issued because you did not appear. So I have 2 times where you failed to appear. Now you can come to the court and say, well, I really didn't know about that date. Okay, but not twice you didn't know about the date.
I know there's no buts or no nothing, but I was released on GPS monitor. Where they picked me up was at my actually address. If I'm not mistaken, the last time was because you didn't. I
I'm having a hard time understanding you.
Yes, could you speak up and talk in complete sentences for us, please?
Is the last time that I was arrested was I was on GPS monitor, but I believe I was letting know my attorney, hey, look, my GPS is saying that I'm a technical violation, and what should I do? I mean, why is she still saying that? It appears that I was supposed to go to a different address, and there was a misunderstanding. Supposedly, that's why I was arrested on 2000 when I first got out on GPS monitor. And the last time we finally got that fixed, and I've been doing good ever since then. It's that my phone was actually stolen. This time that I'm in here right now, my phone was actually stolen. So I barely got paid on Friday. So as soon as I got paid, I went and bought another whole different number, and everybody was letting me know that I have a warrant, and well, I just stayed there waiting for. Not everybody would. That's what my pretrial service officer told me that I was supposed to show. I don't know if I make any sense, but I don't.
Okay.
I know there's no excuse for anything, and I just wish I just have a little 30 days notice because I have a baby on the way. I just want to get settled down. Settled before I do my time. If not, it's up to you, Judge.
All right, thank you. I'm going to deny the motion. I will not reinstate the bond.
Well, in that case, Your Honor, there really isn't any legal reason not to sentence.
And Mr. Salazar, I've read through the file, and in the file, there have been several times where you violated your GPS as well. I mean, you understand, correct?
Yes, ma'am.
All right. Then I'm going to follow the plea bargain agreement that you've reached and cause number 2021-0256. I'm going to sentence you to 5 years in prison. I'm going to give you credit for any time that you've served. There's a $1,000 fine. Time and money will run concurrent. Take in consideration 2020 CR 2990 and County Court Cause number 646257. Next, Mr. Salazar, I'm going to show you a document entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney and did you understand it?
Yes, Your Honor.
And did you electronically sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, and also because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, Your Honor.
All right, Mr. Salazar, good luck to you, okay? Thank you. With that, we'll close the record.
Thank you, Your Honor.
Norma, can you let them know that L5 can go back?
And I also have a Riley Hood that we're writing on.
All right, Raleigh Hood.
Yes,
And where is Raleigh?
should be in court.
Oh, Your Honor.
Hello. All right, what is happening with Mr. Hood?
Your Honor, we were intending to enter pleas of true, and we have a disagreement with the state and probation department as to whether Mr. Riley should be placed on outpatient treatment versus inpatient treatment.
All right, who is the prosecutor?
Marcus.
All right, and Brenna, let me find you. Brenna, are you there? Okay. Everything's moving slow today. All right.
I'm here.
No, it's like my video shows you, but it's like, where is she? All right, the court is calling 2017 CR 1576W, State of Texas versus Raleigh Hood. Could I have parties announced for the record, please, for the state?
Marcus Sanders.
For the defense?
Dan Rodriguez.
And are you Mr. Hood?
Yes, Your Honor.
All right, we're proceeding by video because of the pandemic. The defendant was on Zoom screen, but the court required him to be in the courtroom. Is there any objections to us proceeding by video, state?
No objection.
Defense?
No.
And for the record, Mr. Raleigh is in the court. I'm sorry, Mr. Hood is in the courtroom. Mr. Hood, I'm showing you a document entitled Defendant's Consent to Appear by Video. Did you review that document with your attorney and did you understand it?
Yes, ma'am, I did read and understand.
And did you electronically sign it?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily consented to appear by video. I'm going to show you two documents. One is entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. The other is entitled State's Motion to Supplement Pending Motion to Enter Adjudication of Guilt and Revoke Probation. Did you review those documents with your attorney? And did you understand them?
Yes, ma'am.
Are you the same Raleigh Andrew Hood who was placed on deferred adjudication in 2017 CR 1576W for the offense of possession of a controlled substance, penalty group 1, 4 grams to 200 grams on May 25th, 2017 for a period of 5 years? Is that you?
Yes, Your Honor.
Right. State?
From the original motion, condition number 35, on or about the 12th day of October 2020 in Travis County, Texas, the defendant Riley Andrew Hood did then and there fail to comply with the rules, regulations, or instructions of the Barrett County Community Supervision and Corrections Department Substance Abuse Felony Punishment Facility Continuum of Care Treatment Plan, and that the defendant absconded from the Austin Transitional Residential Center in violation of condition number 35.
How do you plead to that, true or not true? All right, I'm gonna need you to speak up because the court reporter can't hear. How do you plead to that, true or not true?
True, Your Honor.
We'll waive the rest.
Any objections to the state's waivers?
No, Your Honor. Mr. Riley Hood does have an explanation for his violations.
All right. Mr. Hood, do you understand by pleading true to violation of condition number 35, the court could find it true, grant the motion, find you guilty, not grant you community supervision, and sentence you up to 20 years in prison and up to a $10,000 fine? Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 35?
Yes, ma'am. I don't feel it's right to lie to you.
No, my question is, knowing that, do you still wish to plead true to violation of condition number 35? Nobody can hear you.
Yeah, speak up, please.
Yes, Your Honor. Sorry, I don't know. Maybe I'm too far. Yes, Your Honor.
All right, so you're, after everything I've told you, you still wish to plead true to violation of condition number 35?
Yes, Your Honor.
All right, the court will find violation of condition number 35 true. Is there an agreement?
There is not, Judge.
No,
All
Your
right,
Honor.
State, what are you requesting?
Judge, we're requesting in line with probation's recommendation, which is dual diagnosis residential, followed by outpatient cognitive program. Mr. Hood has already been to State P and State ISF.
Defense?
Your Honor, we're asking that he be continued, that Mr. Riley be continued, and that he be placed in some form of outpatient treatment that would potentially address any drug issues and also any mental health issues that Mr. Riley might need. He did complete ISF and he has completed Safe P, Your Honor.
All right, and here's the question though, why did he violate condition number 35?
Mr. Riley, Hood, would you tell the judge why he didn't complete
All right,
35?
if you could raise your right hand for me, please. Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
You can lower your hand. Defense?
Mr. Hood, the judge just asked, why did you violate your probation specifically by leaving the aftercare program?
Yes, ma'am. When I was up in Austin, I was trying to get a few things together. I had a job. I was doing everything that I needed to do for that aftercare program. I'd gone out and I'd purchased a vehicle trying to better assist myself in getting to that job. The vehicle a week later, 2 weeks later, ended up overheating and I got stuck on the side of the highway. I didn't know anybody up in Austin. I didn't know how to get back there. I got stuck. I was contacting the halfway house, letting them know what was going on, what the situation was, and that I was trying to get back there as soon as possible. They finally said, if you're not back by this certain time, which I think it was like 10 o'clock is what they said, we're going to have to abscond you from the halfway house and we're going to issue you a warrant. So I got stuck and I could not make it back before that time. I was over an hour away. So.
Okay, and Mr. Hood, there's also, even though the state's waived these allegations that you did not report for a meeting with your probation officer and also that you did not report for a drug test. Can you explain to the court why you may have missed those two meetings?
Yes. Okay. So the very first day that I was out, I had contacted my probation officer and let her know the situation, let her know that I had been absconded from the halfway house or violated. She had said that she was going to issue a warrant. I've been in this probation for a couple of years now, and I was scared. I don't want to go back into the county jail. I'm trying to do things right. She said I was issued a warrant, man. I got scared. I didn't show up for the PO meeting or the drug test.
Okay. And after that occurred, were you arrested on a warrant?
Yes.
Okay. And how long did you spend in the Bexar County Jail on that warrant?
I was in Bexar County Jail for 2 weeks.
Okay. And since you were released from that warrant from Bexar County Jail, have you been in contact with the probation department?
Yes, sir.
Have you had an occasion to do a drug test?
Yes, sir.
And do you know if your drug test was positive or negative?
I do not.
Okay. But have you been using narcotics since you've been released from jail?
No.
No. Okay. And are you clean today?
Correct.
Okay. And when you left the aftercare program for Safe P, had you successfully completed the Safe P program?
Yes, sir.
Okay. And what was the purpose of the Safe P program for your probation?
What do you mean?
Do you know what the Safe P program addressed, any need that it addressed for you?
The thinking errors, some of the ways that you think they're trying to change it before you actually go and use. That was really the main one is trying to stop you from actually going out and actually physically doing that activity, whether that be some form of negative thinking, like sometimes you get stuck. You make the same choices. You won't see the actual results. You won't see that the choices you're making are affecting how you're acting or how or the things you're doing. Does that make sense?
Right. Okay. Have you taken those lessons that you learned in SafeP and applied them to your life today?
Yes.
Okay. And how are you doing today in your life as far as your personal life and staying away from drugs?
Since being released on bond, I have obtained a job. I've obtained 2 vehicles. My girlfriend is pregnant. She's having a baby in about 2 months. I have my own apartment under my name with all the bills under my name. I'm really trying to do right. I'm doing all right. I really don't need to go to an inpatient. I really feel it's a giant backstep in the progress that I've made. I'm going to lose everything that I have. That's it.
Do you think that going to inpatient treatment will negatively impact your life and also the life of your girlfriend and your expecting child?
Yes, I feel like I'm going to use my apartment. I'm more than willing to do any outpatient that is required.
Okay, will it result in you losing your employment, do you believe?
Yes.
And also your place of residence?
Correct.
Okay. I'll pass the witness.
Defense?
Mr. Hood, have you updated probation on where you currently work?
Yes, they know where I'm working as well as living. They have both of those.
Okay. Are you aware of why you were kicked out of the residential program in Austin?
Yes.
Why is that?
I didn't return.
Okay. And isn't it true that you lied about having a job and you checked out saying that you were going to work, but actually you went shopping?
No, I had a job at Goodwill.
Okay. When did you stop working at Goodwill?
When did I stop working at Goodwill? When I absconded.
Okay, so on October 12th, 2020, is when it's alleged that you no longer worked at Goodwill, but you still signed out saying that you were going to work, correct?
Correct.
Okay. Pass the witness, Judge.
Defense?
No other questions, Your Honor.
I have a question.
Yes, ma'am.
You're tested today. What are the results going to be?
Negative.
Why, when the defense asked you the question, have you had an occasion to do drug tests? And you said yes. And he asked you if you knew the results and you said you're unsure of the results.
Well, I know they're negative, but I've never seen the results physically.
Okay.
That would be a lie.
Well, all right. Why do you think you shouldn't go into inpatient treatment? Because you didn't complete the program. You haven't completed it.
Yes, ma'am. I understand.
So here's the choice I'm going to give you.
Yes, ma'am.
You can go back into inpatient treatment, complete it, or I can revoke you. I'll give you 3 years prison. So if you want to discuss that with your attorney, you can, but either way, today you're not leaving this courtroom. So do you wish to discuss those options with your attorney?
We can do a breakout room.
Yes. I'll send a courtroom. Could you go back to breakout room number 1, please? And Donaldson, have they completed the paperwork?
I think Jordan has sent it, but I don't know the status past that.
Okay.
Jack momentarily. Discovery is done, and Ross has signed the plea paperwork. I assume he's probably going over with his client now.
Okay. And does anyone know Joseph Aaron Gonzalez? What happened with that case? Oh, that's Raymond Martinez. Norma,
Yes, ma'am. I'm sorry. I was on the
Can
phone.
you see if Raymond Martinez can zoom in?
Yeah, he was peeking into the office. I think he's running up and down the hallway, Judge, into the other courts.
All
He's
right.
checking to see if his client has been showing up to court.
All right, thank you.
Your Honor, can you hear me?
Yes, who's speaking?
This is James Burmis. I am a character witness for Mr. Riley Hood. Could you send me to the same breakout room, please?
You can go there if the attorney requests you to be in that room.
Okay. Now, I don't know if the attorney knows I'm on, but I am here as a character witness for Mr. Hood and also his employer.
All right, I will let the attorney know.
Okay, thank you.
You're welcome.
Judge, I'll be right back.
All right, thanks. Mr. Rodriguez? Oh, you're muted.
I was wondering if you, Marcus, and myself could go into a breakout room for 10 seconds.
Yes, and there actually is a person here.
Right.
They're listed as ex Burmis.
He's a witness as well, but I think if we can just do a breakout room really quick, we'll resolve it all.
All right, Marcus, could you go to breakout room number 2, please? And Dan, I will meet you all in breakout room number 2.
Thanks.
All right, are we back? Courtroom, could you unmute, please? All right, we're back on the record in 2017 CR 1576W, State of Texas versus Raleigh Andrew Hood. Mr. Rodriguez, did you have a chance to speak with your client?
Yes, I did, Your Honor. And I believe that we're asking for an alternate.
Yes, Judge. I guess we have an agreed recommendation for your consideration. It would be for you to adjudicate, revoke, and sentence Mr. Hood to 2 years TDC.
All right, is that the agreement?
Yes, it is, Your Honor. And I do have some, aside from his credit in the Bexar County Jail, I do have some other days credit for two times that he's completed inpatient programs.
Okay. Mr. Hood, are you asking me to follow the agreement that's been reached?
Yes, ma'am.
All right, I need you to speak up so we can hear you.
Yes, ma'am. Sorry.
Are you waiving your right to appeal?
Yes, ma'am.
All right, then what the court will do then is the court will follow the agreement that has been reached. The court will find you guilty, grant the motion, sentence you to 2 years in prison, give you credit for any time served and credit for any inpatient treatment time. Is there anything else from either side with regards to sentencing, state?
No, Judge.
Defense?
Yes, Your Honor. I would like to read out the day's credit.
Yes.
ISF from July 18th, 2017 to October 17th, 2017 for a total of 91 days. SAFPF from November 27, 2019 to September 2nd, 2020 for a total of 280 days.
Okay, just as long as the record is clear, he is not going to receive any credit for the time he was at the halfway house because he didn't complete that. But any time where he was in custody, that means in custody for SATF or safety, and any time that he's been in custody at the Bexar County Jail or anywhere else for the offense, he will receive credit for that. So the credit that you're asking for, it's not for the time that he absconded. Is that correct?
Right, Your Honor. I'd ask probation, the CLO department, what he has completed. And those were the two things that he has completed: 91 days in ISF and 280 days in safety.
That would be correct, Judge.
All right, so I will put that you'll receive credit for inpatient. And I'll put the days are 91 days and 280 days. All right, Mr. Riley, I'm going to show you a document entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney and did you understand it?
Yes, ma'am. Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And also because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
All right, good luck to you, Mr. Hood.
Thank you.
You're welcome.
That's all I have, Your Honor. May I be excused?
Yes, thank you for your patience. Bye-bye.
You have a nice day.
All right, you too. Victoria Cruz, you're here on Joshua Aaron Gonzalez.
Yes, Your Honor.
All right, and Ross Rodriguez, I'm going to send you to a breakout room because I believe they have all the paperwork for your client. If you'll go back to breakout room number 4, Ross.
Yes,
and if
Judge.
the clerk will go to breakout room number 4
Yes, Your Honor.
and swear him in. And then Ross, when he's sworn in, if you'll bring him back to the main room.
Yes, Your Honor. Thank you, Judge.
All right, is there a prosecutor available for Cruz Martinez's client? He's not present and he didn't show up for sentencing. Is there a prosecutor available?
Around, Judge, I can stand in.
Thank you. Court is calling 2019 CR 7801W, State of Texas versus Joseph Aaron Gonzalez. Could I have parties announced for the record for the state?
Jordan Brown for the state.
For the defense?
Victoria Cruz on behalf of Raymond Martinez for the defense.
All right, this case was set at 9 a.m. for today. It is now 3:50 p.m. The defendant was not present all morning in the courtroom. the court informed defense that they would recall it for the afternoon to see if their client showed. Deputy Laura, has there been a Joseph Aaron Gonzalez in the courtroom at all today?
No, Your Honor, he has not.
And he has not been on the Zoom screen at all today, and he's still not on the Zoom screen. Defense, have you had any contact with your client?
We have not, Your Honor. We had contact with his mother last night, who indicated that he was undergoing medical issues, but I have not had contact with my client.
All right, State.
Judge, they would request the bond be forfeited and a warrant be issued. That's it.
All right, the court will grant that, and the court will remand your client without bond. If your client has been in the hospital, or if there's some reason why he could not be here, the court, of course, will consider that.
Understood,
Thank
Your
you.
Honor. Thank you. Yes, ma'am.
Have a
May I
good
be
one.
excused?
Yes.
I hate it when this happens.
Bye.
Thanks, Judge.
You're welcome. Is everybody okay? I hear some coughing going on.
Gordon's just choking on his own saliva.
There was a drink involved. It's a little different.
I did.
Not too far off.
Happens to me pretty often. So.
Judge, on page 36, did we hear Lopez?
Oh, let me just find that. Oh, that's
Guillermo?
being recalled for May 5th.
May 5th. Okay. Thank you.
Kevin, you had a question?
No, I thought she was asking about Guillermo Lopez.
Sure. And Rebecca?
Yes, ma'am.
I have a motion requesting an early termination on Lisa Flanagan. It's 2018 CR 5085.
Okay.
And Laura and Joe Ray, if you could check into that to see if you have any objections. It's 2018 CR 5085. Everyone, just give me one moment. All right, Mr. Donaldson, you need to find a parking space. I'm not doing a Zoom while you're driving. So you want to talk to your client about that, and he's driving.
I did tell him, Judge, I think he had said he was pulling over, Your Honor, if I'm not mistaken.
Okay, all right, I'll wait till he pull over. I'm not going to be the cause of an accident.
I'm stopped already.
Okay,
Yes, ma'am. Sorry about that.
no problem. Brenda, are you ready?
I'm ready.
All right, who's the prosecutor who's on this?
It's Tom, Your Honor. I believe he may have gone to do something, Judge.
No, he's here.
Okay. There he is.
I did the paperwork so I can do it unless Tom wants to.
All right, whoever wants to go, I'm fine with that. All right, the court is calling 2021 CR 1166, State of Texas versus Christopher Donaldson. Could our parties announce for the record, please, for the state,
Gordon Brown for the state.
for the defense?
Ross A. Rodriguez for the defense, Your Honor.
Are you Mr. Donaldson?
Yes, ma'am.
We're proceeding by video because of the pandemic. Any objections from the state or the defense?
No objection, Your Honor.
No objection from the state.
Mr. Donaldson, I'm showing you a document entitled Defendant's Consent to Appear by Video. Did you review that document with your attorney? Did you understand it, and did you electronically sign it?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Counsel, I'm showing you the acknowledgement of discovery. Have you received all the discovery in this case, and did you review it with your client?
I received it, Your Honor.
Court will find that the state is in compliance with discovery. And did you review the discovery with your client, Mr. Rodriguez?
Basically, we've talked about the discovery, Your Honor. I don't know if he's actually seen all of it, Judge. I can do that now.
Mr. Donaldson,
Yes, ma'am.
have you received all the discovery and had a chance to review it with your attorney?
I don't believe so. I don't think that I saw all of it, but I'm not sure.
Here's the question. Did he go over the documents with you?
Yes.
Did he go over the police reports with you?
Yes.
Did you see the laboratory report from the police reports?
No, ma'am.
All right, Mr. Rodriguez, can you show him or discuss with him the laboratory reports, please?
Yes, Judge. Yes.
All right, Mr. Donaldson, I'm going to
Yes.
see you in breakout room number 3.
Okay.
And after you finish speaking with your attorney, just come back to the main room, please.
Thank you, Judge.
All right, you're welcome. Thank you.
Judge, can I go into a breakout room with Laura or Joe Ray, whoever's gonna look into that one case? Lisa
Sure.
Flanagan.
Who's it going to be?
Doesn't matter, I can deal with it, Judge.
All right, I'm sending Rebecca to breakout room number 1. So whomever wants to travel to breakout room number 1.
Laura, I can go if you want. Judge, I don't have the ability to move.
Oh, I'm sorry. Let me find you, Joe Ray.
Thank you.
All right, there you go.
Your Honor.
Yes?
Okay, he's recalls it all, Judge.
All right, thank you.
Yes, Your Honor.
All right, we are back on the record in 2021 CR 1166. Mr. Donaldson, have you
Yes, ma'am.
have you seen and has your attorney spoke with you about all of the police reports in this case?
Yes, ma'am.
And did you get a chance to review the laboratory reports with your attorney?
Yes, ma'am.
Have you seen everything you wish to see in this case?
Yes, ma'am.
Then, as previously stated, the court will find that the court will find that the state is in compliance with discovery. Mr. Donaldson, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, it appears that you're waiving the enhancement allegations.
That is correct, Judge.
Any objections?
No objection, Your Honor.
Mr. Conkey, I'm showing you what's entitled Court Admonishments. Did you review that document with your attorney and did you understand it? Mr. Conkey.
Donaldson, Your Honor.
Oh, sorry. This is what happens, Brenna, when you have like documents before you. I have like 10 different documents before me. I'm sorry, Mr. Donaldson, I'm showing you what's entitled Court Admonishments. Did you review that document with your attorney? Did you understand it? And did you electronically sign it in all the appropriate places?
Yes, ma'am.
All right. Because the state waived the enhancement allegations, what you're charged with is possession of a controlled substance, penalty group 1, less than 1 gram. It's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in a state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter to a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor.
Do you believe he has a rational as well as factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Donaldson, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Next, I'm showing you the plea bargain page. Did you review that page with your attorney and did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishment is to be assessed at 12 months in the state jail facility. There are no applications. The state will take in consideration the following county court cause numbers: 655-051, 655-052, 648-044, JN numbers 200-3323, 200-3316, 2011432, JN number 1998712, JN number 1998711, and you will be subject to the full range of punishment, and TIC agreements are void if you fail to appear for sentencing. And do you understand the full range of punishment?
Yes, ma'am.
State?
Yes.
If he
That
doesn't,
is the agreement.
I'm sorry, if he doesn't appear for the full range of punishment, the full range of punishment the state is speaking of is just on a state jail felony, is that correct?
Yes, Judge, because we waived the enhancements, I think he's only subject to the full 2 years.
All right, do you understand that, Mr. Donaldson?
Yes.
All right, do you understand that it's the entirety of the plea bargain agreement, Mr. Donaldson?
Yes, ma'am. So what they're saying is, as long as I show up, I'll get the 12 months, correct?
Yes.
Okay. Yes.
All right, defense, did you understand that to be the entirety of the plea bargain agreement?
Yes, Your Honor.
State, is that the plea bargain agreement?
Yes, Judge.
Next, I'm showing you the paragraph entitled waiver of appeal. Did you review that paragraph with your attorney? Did you understand it? And did you electronically sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then, Mr. Donaldson, to the indictment, how do you plead? Guilty, not guilty, or no contest?
Guilty, ma'am.
State, any evidence to support the defendant's plea?
State offers states Exhibit 1 and attachments.
No objection, Your Honor.
Mr. Donaldson, I'm going to show you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? And did you electronically sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements, police reports, laboratory reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states Exhibits 1 and attachments, and the court will review the same. Having reviewed states Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing or no? Defense?
No, Your Honor. Would like to request a reset for sentencing, Judge.
What time are you requesting?
Well, Judge, the court is aware that his stepfather is going through chemo, and I'd like to at least request 45 days, Your Honor, to come back.
State?
Judge, I didn't make the agreement. I don't know if we have an agreement. Otherwise, I would defer to the court's judgment.
I never spoke with the state about it, Judge. That's what I was requesting here, Judge.
Completely on.
So, Judge, I think our bases are covered in the language of the contract, so we defer to the court's judgment on the appropriate date.
All right, Ms. Ferguson,
Yes, ma'am.
could you give him a 45-day reset? And Mr. Donaldson, you are to appear in court. It's the 187th District Court. It's 300 De La Rosa, the 4th floor. Do you understand?
Yes, ma'am.
All right, Norma, what time should he be back?
Give me 1 second. Come back on May 12th.
All right, and that's at 9 a.m., Mr.
Okay.
Donaldson.
Yes, ma'am.
So what time are you to be in court?
May 12th, 9 a.m.
And what is the court number?
It's 187.
Yes. All right. We'll see you then. You're
Okay, thank you.
excused.
Okay, thank you.
Your Honor.
Thank you. All right, everyone, we are done for today. So I'm going to stop live streaming.